and the award will be final and binding.
All right, we can go into the opening statements, but we begin with you now for the company.
Mr. Arbitrator, we intend to prove that the grievant in this case violated the uniform and appearance standards of the company. He refused the direct orders of his supervisor. In addition, he physically threatened supervisors and cursed a female supervisor. He has already been warned for insubordination, and the sum of his conduct justifies the 1-week suspension. We ask, sir, that you uphold that discipline.
We completely disagree with the company's position. There are two issues, one dealing with a rule and one dealing with a question of insubordination. It is our position, and we have witnesses to prove, that there is no rule. The company will not be able to produce a rule concerning uniforms. With respect to insubordination, the grievant himself will testify that he used no insubordinate language, made no rude or threatening gestures, and his testimony will be corroborated by a co-worker.
All right. I'd like to swear the witnesses collectively. Would you raise your right hand, please? Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God? 1, 2, 3, 4, 1, 2, 3, 4, testing, 1, 2, 3, 4. Susan, this is a first draft of the matter of a controversy between B&H Transit Company and Conveyance Union Local 831. Now the facts. On May 4 of this year, the grievant, Howard Kelly, was given a 1-week disciplinary suspension for the following acts of misconduct. Refusing to carry out a direct order of his immediate supervisor, using abusive language to this supervisor, physically threatening another supervisor, and failing to comply with a company rule which requires that uniforms be worn during working hours. Witnesses of the company at the arbitration hearing gave the following company version of the incident. Step forward, please, and give the reporter your full name.
Maria Alvarado.
All right, thank you. All right.
Miss Alvarado, when did you first come to work at the transit company?
A year and a half ago.
And in what capacity were you first employed?
I was an information booth attendant.
And have you recently had a promotion?
Yes.
How recently was that?
3 weeks ago.
At what time on May 4th did you arrive at the Evergreen Street station?
10 minutes to 6.
Testimony in the hearing disclosed that Ms. Alvarado had been promoted to supervisor in the company's recent effort to comply with the government's affirmative action directive requiring equal status and pay for women employees. She was promoted in spite of considerable resistance on the part of several old-line supervisors. It was on the 8th day in her new position that the incident occurred, bringing about the 1-week suspension of the grievant Kelly.
I have to catch a train in a few minutes to get to my class tonight, so I thought I'd get ready to go.
I'm sorry, Mr. Kelly, but you know the company rules about uniforms.
Look, if I put the jacket back on now, I'm just going to have to take it off again. I'll be in uniform tomorrow.
Mr. Kelly, I'm going to have to give you an order. Please put on your company coat and tie.
And what happened after that?
Well, a few children came by, and the next thing I knew, Mr. Huff started to walk in.
Do you know approximately what time this was when Mr. Huff arrived?
I think it was about 5 minutes to 6.
Good evening. Good evening, Miss Alvarado.
Good evening.
Everything all right?
I may have a little problem. I just saw Mr. Kelly with his uniform coat and tie off. I ordered him to put it back on, and I'm waiting here for him to return.
All right, we'll both wait.
Mr. Kelly, I told you to put on your uniform coat and tie.
Look, if I put it back on now, I'm just going to have to take it off again.
I'm sorry, Mr. Kelly, but if you don't put your uniform coat and tie on, I'll have to report you to management.
Look, I'm not going to take that crap from you, bitch. Oh, wait a second there, Kelly. And you watch out. If you leave, Mr. Kelly, don't bother to come back to work tomorrow.
And there you are. Clear-cut insubordination in refusing to obey a direct order, use of abusive language, threats of physical violence upon a supervisor, and failure to comply with the company's uniform dress code. But the grievance story differed from the company's version on almost every critical point.
I want to direct your attention to the occurrences of May 4th. What did she say to you?
She came up to me. I was standing in the booth, and she came up to me, and she asked me where was my jacket, where was my uniform jacket.
About what time of day was that?
About 2 minutes to 6, I was ready to leave.
Mr. Kelly! Mr. Kelly!
Miss Alvarado.
You're out of uniform.
Well, I'm leaving to catch my train to go to my class tonight. I thought I'd get ready to go.
I'm sorry, Mr. Kelly, but there are company rules.
Well, look, if I put the jacket back on now, I'm just going to have to take it off again. I'll be in uniform tomorrow.
In that case, Mr. Kelly, I'll have to report you to management.
Come on, lady. Look, it's time for me to go. I'll see you tomorrow. Kelly! If you leave now, don't bother to come back to work tomorrow.
But there you have it. According to the union's interpretation and its testimony, no direct order, no insubordination, no abusive language, no threat of violence, no violation of any company rule on the wearing of uniforms because there was no company rule. So where was the truth? As is so often the case, the arbitrator must make a decision based upon credibility. There is such a conflict in the evidence. And how does he get there? He certainly does not want to reward the most convincing liar, nor is it the purpose of this film to teach witnesses how to lie convincingly. But it is our objective to help witnesses to get their stories across in a believable way and to help correct the kind of behavior that interferes with that. So, let's take a look at the witnesses' behavior. See how they helped or hurt their case and how this affected the outcome of the arbitration. Since it is the company that shoulders the burden of proof in discipline cases, company witnesses were called first. And so, let's have a look now at Ms. Alvarado's testimony.
And when did you first see Mr. Kelly?
Well, I was about to go down the escalator.
Not responsive.
Listen to the question, Ms. Alvarado. When did you first see Mr. Kelly?
10 minutes to 6.
Now, there is a very common fault among witnesses, probably the most common. Failure to give a direct response to the question asked. She was asked a simple question: what time did you first see Mr. Kelly? She answered something else, and when she was finally prodded, she gave a hesitant answer. Now, this not only delays and prolongs a hearing, but it begins to suggest that her credibility is an issue. It dilutes her credibility. What should she have done? She should have either said, yes, 10 minutes to 6, or I don't know, or I'm not certain. That's what she should have done.
After you advised Mr. Kelly that he was not in proper uniform and was not living up to the dress code, what happened?
He's leading the witness. He's putting words in the witness's mouth, Mr. Arbitrator.
I think that's true. You can do better than that.
What happened after you advised Mr. Kelly concerning the dress code?
Well, he walked over to the men's room.
All right. When did you next see Mr. Kelly?
Well, the next moment that I remember was that after I had talked to Mr. Huff, Mr. Kelly started to come out of the bathroom. And then I noticed that he did not have his uniform on.
I see. What did you do?
I told him, I said, Mr. Kelly, I told you before that you had to change to your uniform coat. And this time I ordered him to change into his uniform coat.
I would move to strike the phraseology ordered. Let her tell us the words she used.
That's a proper objection.
What did you say?
That is a proper objection because whether there was an order goes to the strategic and ultimate issue in this case. If there was no order, then the grievant could not have been insubordinate. And by her characterizing what she said as an order, she is interpreting and drawing conclusions about the facts, a province which is reserved for the arbitrator.
Exactly what did you say?
I told him to get into his uniform.
What were the words used by the witness, Mr. Arbitrator?
That's proper. What did you say?
I said, Mr. Kelly, get into your uniform.
And what did he say?
He said that he didn't have to get into his uniform. He didn't feel that he had to because there was only a few minutes left. And then he proceeded to call me some abusive language.
Oh, abusive language. What did he say?
He said,
Miss Alvarado, I know it's difficult for you, but we're all grown-up people here, and we have a proceeding going. It's very important to know the precise words. What did he say?
He said, I don't have to take any crap from a bitch like you.
And what happened at this point?
Well, Mr. Huff got in between us. I guess he thought that Mr. Kelly was going to hit me or
to
something.
strike any thought, Mr. Arbitrator.
Proper objection.
Yes, I accept the objection.
A witness should not and cannot testify about what someone else thought.
Did Mr. Kelly turn around and say anything?
No, he didn't. He just kept on walking off. And I stood there shocked.
I don't think it makes any difference how she stood there and whether she was shocked, Mr. Arbitrator. That's not part of the discipline.
And not to try to give one's personal reactions, no matter how important and how valid they might be.
Isn't it true that you've only been a supervisor for 3 weeks?
So, Miss Alvarado, may I suggest, you spoke up quite distinctly on direct, and this case here involves a credibility matter. We would like you to be as forceful as you were on direct examination. Keep your voice up.
Responding to cross-examination by the opposing counsel is generally a lot tougher than answering the sympathetic questions of your own attorney.
Now, directing your attention to the events of May 4th, ma'am. What time did you come to the platform?
Well, to the best of my recollection, it was 10 minutes to 6.
Well, you're somewhat hesitant now, but you were very positive when your attorney asked you the question about the time. Is there some reason for your hesitation?
No.
But you're not positive it was 10 minutes to 6. It could have been some other time, isn't that correct?
No, I'm positive. I checked my watch.
Why did you hesitate now, ma'am, if you were so positive?
Mr. Arbitrator, counsel is badgering the witness. He's already asked that question.
Well, his question is proper. It's the tone that has a little bite in it.
It is often part of the legitimate job of the opposing counsel to attempt to discredit or dilute your testimony, and he may be inclined to use an aggressive manner or even harsh tactics in trying to confuse and upset you. Remember, you are not responsible for the questions that he asks, only for your own answers.
And no one expects you to have a perfect memory.
I'm very interested as to what time it was when you first arrived at the platform. That's a critical issue here, and I really want to know what time it was and why you're so sure. Now, why are you sure now that it was 10 minutes to 6 when you hesitated a moment ago?
You asked me what time it was. I looked at my watch and it was 10 minutes to 6.
You looked at your watch as you walked up to the platform or before you came to the platform?
It was, before I came to the platform.
And did you look at your watch when you first saw Mr. Kelly?
Oh, wait a minute. It was after I came to after the platform.
Now you say it was after you came to the platform. A moment ago it was before you came to the platform. Which time were you not telling the truth, ma'am?
Oh, Mr. Arbitrator, I object to your characterization of the witness testimony.
Well, she's already told two stories, Mr. Arbitrator. Only one can be true.
But counsel, you know that it's for me to decide, and it's only for you to produce the facts.
Very well, Mr. Arbitrator. I'll push forward on this matter. Did you swear at Mr. Kelly on the day of the 4th?
No, I never swear.
You never swear. You never swear and you never raise your voice. Is that correct, ma'am?
Yes.
I have no further questions.
And there you have a pretty shaky witness, leaving real doubt in the arbitrator's mind as to what the truth was of what she really said. Let's have an instant replay of a part of the testimony, but the way it could have been, should have been.
You never swear. You never swear and you never raise your voice. Is that correct, ma'am?
Yes, I do sometimes.
But you didn't on this occasion?
No, I didn't.
I'm very interested as to what time it was when you first arrived at the platform. That's a critical issue here, and I really want to know what time it was.
It was 10 minutes to 6.
Did you look at your watch before you came to the platform or after?
After.
Why are you sure now that it was 10 minutes to 6?
Because I saw an overturned trash can, and I was about to walk toward it. And then I noticed that Mr. Kelly was out of uniform. So I thought, well, that's strange, and I checked my watch. And I saw that it was 10 minutes to 6.
Was it 10 minutes to 6 before you started your conversation with Mr. Kelly?
Yes, it was.
Call your next witness, please.
I'd like to call Mr. Hoff.
Step forward. Evidence showed that Hoff was one of those supervisors who first opposed the promotion and upgrading of women to supervisors until he had to be convinced by higher management that he had to support the affirmative action program.
So, Mr. Hoff,
This, of course, suggests the possibility of overreaction in this situation.
did you give Miss Alvarado her orientation in supervisory training?
Yes, I did. I'm her head supervisor, and I
The question,
informed her.
excuse me, Mr. Hoff, the question simply asked you for a yes or no answer. What is the answer?
Yes.
Right, thank you.
I did.
Now, turning to May 4th, when was the first time that you arrived at the station and saw Miss Alvarado? What time was that?
I arrived at the station and saw Miss Alvarado there. She was very unhappy.
Mr. Hoff, what time is the question?
I would believe it was probably about...
Mr. Arbitrator, I'm not interested in his beliefs. Either he knows what time it was or he doesn't know what time it was.
Well, Mr. Arbitrator, he may not know the exact time, but I think he's entitled to give you the approximate time.
Well, Mr. Hoff, I know you're trying to help us, and we want you to help us. But try to listen to the question and be directly responsive to the question. What you know, you know. What you don't know, you don't know. There's no harm in not knowing certain things. All right, let's try again.
Can you tell us the approximate time that you arrived at the Evergreen station and saw Miss Alvarado?
Well, I'm not exactly sure of the time. It must have been around just a little before his 8 hours were up.
Well, what does that mean? Do you know what time his 8 hours are up?
Well, yes, his time is up at 6 o'clock. When I arrived there at the scene, now he had, his time wasn't up yet because he was in there. She had already told him about his uniform. He had taken his uniform off, and she...
Mr. Arbitrator, I would move to strike this testimony. He can't testify as to what happened before he got there.
That's true. Just listen to the question and try to confine your answer to the specific questions that's being asked you.
That's what I thought I was doing.
Well, you weren't doing it very well. Try again. And here we have another example of a poor witness. Everything he has to say may be the exact truth, but in the cold light of the transcript,
even in answer to his own counsel, it is very hard to believe. It is particularly harmful to his case when he volunteers information.
Did Mr. Kelly come out of the dressing room?
Yes, he did come out of the dressing room, and he didn't have his uniform on.
Did he say anything to you, or did you say anything to him?
He threatened me.
When asked what was said, the witness used descriptions like threatened. That is opinion evidence. That is a conclusion, and that is for the arbitrator to decide. What the witness should have said is what he saw and what he heard.
What do you mean by threat? Well, he shook his fist at me, and he told me, "Now you look here." He went like that.
When Mr. Kelly came out of the dressing room, did you hear Miss Alvarado say anything to him?
She asked him why he wasn't in his uniform.
And then what happened?
And then Mr. Kelly badmouthed her.
What do you mean by badmouth?
Well, he called her some dirty names.
You can say. What did he say?
All right,
specifically?
Look, I don't have to take that crap from you, bitch.
Oh, wait a second.
And you watch out.
Kelly, if you leave now, don't bother to come back to work tomorrow. Don't bother to come back in tomorrow. Don't come to work tomorrow. That's what I told him. It's like that.
All right. I have nothing further, Mr. Arbitrator.
Now let's consider the credibility of a competent and experienced witness. His answers are thoughtful and complete, and yet unhesitant and directly responsive to the questions asked.
I'd like to call John Matheson.
All right, step forward. Get a report of your full name, please. John Matheson.
Thank you. Mr. Matheson, what is your position with the company?
Assistant Vice President in charge of personnel.
Have you specifically been involved with the rule that has to do with wearing uniforms?
Yes, as a matter of fact, I initiated.
Would you tell the arbitrator about that rule?
Well, the rule states that employees must wear the uniform supplied to them by the company at all times while on duty.
And why did you initiate that rule?
Prior to that, there was a haphazard practice of either wearing uniforms or not.
And how has that rule been communicated?
In two ways. One is a new employee initiation and orientation program, wherein employees are brought into a room a few at a time, and they are told the rules, the reason for the rules, and told how they're going to be enforced.
You said two ways. What's the other way?
The other way, we placed notices on all restroom mirrors.
Did you in fact review Mr. Kelly's performance with respect to this disciplinary action?
Yes, I have.
What about the situation for which he was warned previously?
Mr. Kelly refused to report to the shift that he was assigned to, and on the basis of that, we felt he was engaging in self-help, an act of insubordination, and we felt the written reprimand was a just penalty for him.
Why did you give him a 5-day suspension?
Because of an incident that took place on May the 4th, and on the basis of review of his past record.
Now, on May 4th, did you characterize what he did as insubordination or self-help?
Both. And the refusal to wear a uniform, which is insubordination.
Did you determine that a week's suspension was appropriate under the circumstances?
Yes. But first we talked about this judge.
Why did you decide upon a suspension at all?
I mean, rather than some other punishment?
Yes, less than punishment.
Hopefully, on the basis of that, he would take the opportunity to correct himself. And this judge, we felt, we don't like to discharge people. He's a relatively young man and might be on his record for the rest of his life.
I have nothing further, Mr. Arbitrator.
Now, even on cross-examination, the benefits of experience show up. Instead of trying to duck a possibly damaging question, the witness answers it straight. Counsel, you may cross-examine.
Now, when you were investigating this case, sir, did you ever ask Mr. Kelly his version of the story?
No, I did not. I relied on Mr. Hoff and Ms. Alvarado.
You imposed your discipline after talking to two management people without getting the grievance version of the story. Is that
In this
true?
case, I did, yes.
As you can see, the witness is not responding defensively. He knows that he is not responsible for the demeaning tone of the question, and so he simply does not rise to the bait.
I understand you're a Marine Colonel, is that correct?
Correct.
So you have a particular feeling about uniforms that some other person might not have.
I wouldn't say so.
Don't you expect your people to look military?
No. Nor would I expect someone in the airlines to think military with respect to airline stewardesses.
And so far, so good. Effective answers, somewhat rounded out for clarification, but still directly responsive to the questions. But then the opposing counsel got his teeth into one slip on the part of the witness.
You say that you were responsible for promulgating the rule, is that correct?
Yes.
Have you ever seen the rule in writing after your ideas about the rule were discussed?
I believe I saw one on the restroom mirror.
So
3 years ago.
He volunteered one bit of information that wasn't asked for, the fact that it was 3 years ago, and opened up an attack on his knowledge and hence his credibility.
last time you saw it was 3 years ago, this important rule, is that right?
Yes. Well, last time I was in the restroom.
Oh, Mr. Arbitrator, I object to pursuing this line. It has nothing to do with the issue at hand. It's not relevant. It's immaterial.
Your witness volunteered certain information. He's bound by his testimony, and I have to give the opposing counsel opportunity to inquire. I'm sorry. Go ahead.
Is that so? You mean an employee restroom?
Yes.
Yes. What was the wording 3 years ago, the last time you went to the bathroom?
As far as I can recall, it said employees shall wear their uniforms at all times while on duty.
When was the last time that you were down to observe the implementation of the rule?
About a year and a half ago.
A year and a half ago. I see. And you went down once a year and a half ago, and how often before that?
Well, before that, I think I might have gone down about 4 or 5 times.
So you have physically been down to see where workers work about 5 times in the last 3 years. Isn't that a fair statement?
Yes.
Mr. Arbitrator, may I interrupt?
Yes, sir.
We do not intend to show the enforcement of this rule through this witness. And we do intend to call a witness at a later time.
All right, why don't you bring that witness in, and you will confine your questions on the subject that you were pursuing, or confine it to the witness that will be produced.
Very well.
You repeat the question.
Here is a witness who wants to look good, and he wants his company to look good.
Mr. Arbitrator, I'd like to call Mr. Carlton.
Step forward, please. Do you swear the testimony you're about to give is the truth, the whole truth, nothing but the truth, so help you God?
I do.
All right, sir, be seated and give the reporter your full name.
Albert Carlton. What is your current assignment?
I am district supervisor for the company.
Among your duties, do you enforce the rules and regulations of the company?
Yes, I do, all of them.
Do you enforce the rule with respect to wearing the uniform?
I do whenever it's necessary, but it's not often necessary.
He tries to figure out what he should say instead of simply saying what he knows.
Now, do you take inspection trips around the stations and on the trains?
Oh, yes. I try to get out of the office and into the field something like twice a week at least.
How many times do you visit the Evergreen Station in the course of a week?
The Evergreen Station.
Yes.
Probably once, I guess, yeah.
Do you observe the information booths at the various stations?
Oh, yes, that's a very important part of our whole company.
And when you visit the Evergreen Station, you inspect the information booth?
Oh, absolutely. That's where we have the closest contact.
Excuse me, Mr. Carlton, the answer to that question would be simply yes, would it not?
Yes.
Okay, thank you.
Yes, it would.
In the past year, Mr. Carlton, have you seen Mr. Kelly out of uniform?
No, I can't say that I have, no.
In the past year, have you seen any other employees who are out of...
No, they're just, the uniform thing is a very important thing with us.
On cross-examination, we see another common fault. Here the witness repeats the question before he gives the answer. To the arbitrator, that can sound like he is stalling.
You say that there were orientation meetings at which the uniform rule was discussed. Did you ever see Mr. Kelly at such a meeting?
Did I ever see Mr. Kelly at such a meeting? I don't really remember actually having seen him at a meeting.
Actually, you couldn't testify under oath that he ever attended such a meeting.
No, I couldn't. He, I'm sure, has been assigned to those meetings, though.
If he had gone to a meeting, he would have signed an attendance roster, wouldn't he?
Would have signed an attendance roster. Yes, that's the procedure.
Now let's look at the union witnesses and see how they stacked up. You call your first witness.
Yes, Mr. Arbitrator, our first witness is Mr. Bugatti.
Would you give the reporter your full name, please?
Angelo Bugatti, B-U-G-A-T-T-I.
All right, thank you, sir.
What is your title or position with Local 831?
Vice President, sir.
How often do you visit the premises of a company, if at all?
On a daily basis.
Sorry. Have you observed employees within the last 2 weeks who were not in full uniform?
Yes, I have.
Is there anything different about what you've observed in the last 2 weeks than what you've observed over the past 2 or 3 years?
No.
Has the company at any time transmitted to the union any written rule?
Relating to uniforms?
Yes.
No.
Has the company at any time advised the union in writing concerning a rule about uniform?
No, they have not.
Has the company at any time sought to include such a rule in the contract?
They have not.
Is there a rule concerning uniforms in the contract?
There is not.
Have you ever observed any rule concerning uniforms posted on the company bulletin boards?
No, I have not.
No further questions.
Again, a thoroughly credible witness on direct examination, simple direct answers. But on cross-examination, here's some of the wrong and the right of it.
Have you ever seen employees within this period of time attired in sports coats in the information booth? Anyone other than Mr. Kelly?
I would have to probably go down our membership list and talk to the individuals. I make a mental note of things like that. It's happened so darn often that...
Have you ever seen employees within this period of time attired in sports coats in the information booth? Anyone other than Mr. Kelly?
Yes.
How many?
I can't recall.
All right, now I have another question for you. You say you're not aware of any written rule.
Correct.
Do you distinguish between a policy and a rule?
Yes, I think that we can say that.
Well, how do you say it?
There's nothing in this agreement, and Counsel, I'm sure you've gone over it, which specifically mentions the word or phrase or paragraphs as to uniform regulations and when it should be worn. Now, that's the thing which our members are governed by.
Well, as you know, Mr. Bugatti, not everything can be put in the union contract. And those things that are not in the union contract are reserved to the employer and to the employer's policy.
We are aware of that.
Period.
Do you distinguish between a policy and a rule?
Well, a rule becomes a rule when it is adopted by the company and agreed to by the union.
What about a policy?
I'm not sure. I don't know what it is.
That's all.
If prior warning or notice had in fact taken place, and if then the grievant had disregarded the rule, the company's case would have been significantly strengthened in establishing the existence of an enforceable rule. Period. In the absence of such showing, even within the company's own terms, discipline separately based upon a failure to observe the company rule would not be warranted. We are therefore left only with the issue of insubordination. The next union witness was the grievance relief man, Robbins, credible under direct.
At the time you came back to the information booth with your cup of coffee, did you see Mr. Kelly in conversation with anyone?
Yes, Miss Alvarado was coming up.
Was he talking to her or not?
Well, they were involved in the conversation, yes.
Now, at any time that you saw Miss Alvarado speaking to Mr. Kelly and vice versa, were you able to hear their conversation, that is, their actual words?
Well, there was noise going on there, and while I can't say that I heard every word that was said by all the people involved, I did hear enough of it to get the gist of what was going on.
About how many feet away from them were you at the time that you heard their conversation?
Oh, I think I probably might have been about 15 feet somewhere.
I'll be in uniform tomorrow.
In that case, Mr. Kelly, I'll have to report you to management.
Come on, lady. Look, it's time for me to go. I'll see you tomorrow. Kelly, if you leave now, don't bother to come back to work tomorrow.
Did you at any time see Mr. Kelly gesture in a threatening manner towards Ms. Alvarado, like with a clenched fist?
I didn't see any clenched fist or anything like that.
Did you ever see him make such a gesture towards Mr. Hoff?
No.
The snags came with cross-examination. Consider the difference between evasive answers and direct, frank responses, and yet both tell exactly the same story.
Do you socialize with Mr. Kelly?
No.
Have you ever been to his home?
No, I never have.
You haven't even been to a ball game or two with him?
Yes, I did go to one.
Now one wonders whether this is the tip of the iceberg. Had he said it this way, there would have been no question about his credibility.
Do you socialize with Mr. Kelly?
We went to a ball game once, but that's about the extent of it.
You talked to your counsel before you arrived at this proceeding.
Many witnesses are flustered by this kind of question. But there's absolutely no harm in testifying that you have been interviewed by your counsel. It is customary procedure, it is expected, and there are hardly any attorneys, certainly competent attorneys, who do not interview their witnesses.
You talked to your counsel before you arrived at this proceeding.
Yes, I have.
And what did he tell you?
He said to tell the truth, and he heard.
And now for the grievant himself. Much of the case hangs on his testimony. You've seen how a witness should testify. Now see if you can put it all together. You be the arbitrator. Ask yourself, do you believe this witness? If so, why? If not, why not?
All right, give the reporter your full name, please.
Howard Kelly.
Be seated. Thank you. All right.
Mr. Kelly, you're the grievant in this case, is that correct?
That's correct.
How long have you been employed by the company?
3 years.
All right, now you've been here today while Ms. Alvarado and the other witnesses have testified. You've heard all their testimony?
Yes, I have.
How long have you been going to class?
About 2 years.
Have any supervisors seen you in your street clothes 2 minutes to 6 or so?
Yes.
Has anyone ever reprimanded you before or told you that you should not do this?
No.
Okay, go ahead now. Pick up the story where she told you that she thought you ought to be in uniform.
I told her that I'd taken it off, that I was getting ready to catch a train so I could make my evening class. And she said to me that, I know that, she said I'm supposed to know that I'm supposed to have my jacket on until I leave. And I said, well, I do this every Tuesday and Thursday when I go to my class. And I told her that since it was so late, it would be silly for me to put it back on because I just have to take it off again, but that I would be in uniform the next day.
What did she say to that?
She said, well, in that case, I'm going to have to report you to management. I said, look, forget it. Come on, lady.
Well, again, it's very important for the arbitrator to know exactly what you said.
What exactly I said was, forget it. Oh, come on, lady.
What did she respond to that?
Well, at that point, it was time to go. So I just turned to leave, and Mr. Huff came up.
Okay, did you at any time threaten Ms. Alvarado or Mr. Huff?
No.
Did you at any time use any gesture such as a clenched fist or other gesture that might be interpreted as threatening in any way?
No.
That's either towards Ms. Alvarado or towards Mr. Huff.
No, I did not.
Okay. Can you tell me how it was that you knew that it was 2 minutes to 6 when Ms. Alvarado first engaged you in conversation about your coat?
I just looked at my watch.
Okay, you normally wear a watch?
Yes, sir.
Thank you very much. I have no further questions.
All right, you may cross-examine.
Who is your immediate supervisor, Mr. Kelly?
Her.
Who?
Her. Mr. Kelly, you have to identify who her is for the record.
Miss Alvarado.
All right, thank you.
Have you had difficulties in the past with Miss Alvarado?
In the past, no.
Do you have any difficulties in the present with Miss Alvarado?
Well, I guess I did, yeah.
All right, you don't like Miss Alvarado, do you?
Do I have to answer that?
Yes.
No, I don't.
Why don't you like her?
Well, she was promoted over me.
She's also a female, is she not?
Yeah.
We'll stipulate to that.
And you don't like female supervisors?
Not particularly.
You don't carry out an order of a female supervisor because you don't like them, is that right?
Mr. Arbitrator, I object to that question. It's an argumentative question.
It is argumentative. Did you fail to carry out the order which Miss Alvarado gave you because you didn't like her?
Wait, she never gave me an order.
Well, now, don't you know that that uniform is to be worn right up until the end of the shift?
Yeah,
What were you
but-
doing out of uniform 2 minutes before, even if your statement is taken?
Well, that's never really been enforced. You know, I mean, a lot of the guys do it.
Who does it?
There are a lot of the fellas that, you know, if they're getting ready to leave, they'll take their jackets off.
They take them off when they're
Yeah,
inside the
it's
booth?
never been enforced.
Let him ask the questions, and then you give him an answer, give him a direct answer. All right, go ahead.
Now, there have been 2 witnesses that have said that you were absent from the booth in the dressing room 10 to 12 minutes prior to the end of your shift.
That is not true. I mean, I went, I picked up my coat and I came back and I put on my jacket and I was there.
When did you go to get your coat? 10 or 12 minutes before the end of the shift?
No, it was about 5 minutes before the end of my shift. Tim Robbins had already come on and he was there and it wasn't busy, so I went and got my coat.
Did Miss Alvarado ask you to put your uniform back on?
No, she just informed me that I was supposed to be in uniform and I said, it'd be silly for me to put my jacket back on since I was leaving and...
Just answer his question. You don't have to give him any more than he asked for.
Did you fail to carry out a request of hers to put your uniform back on?
She never made a request.
Well, didn't you say in your direct examination that you turned to her and you said, "Come on, lady, it's time for me to go"? Didn't you say that?
I said, "Forget it, come on, lady." And then it was time to go, so I turned and left.
What did you say, "Come on, lady," to? She must have asked you something.
I mean, she was, saying she was going to go to management and report me, because I was getting ready to leave.
What did you do with your hands? Did you raise them?
No, I
When you
said,
this?
forget it, come on, lady.
May the record show the witness is gesturing. No clenched fists.
Now, you're a pretty angry fellow, aren't you?
I would object to that. Mr. Arbitrator, that's a totally inappropriate question. He's arguing with the witness and he's badgering him as well.
I don't think we need to go into that.
Well, I think it has to be shown for the record that this is an excitable man.
Why don't you go to some facts,
and that
some
he
events?
Well, he has a history of insubordination.
There is no history shown here.
Well, we do have a reprimand.
That's a reprimand, but a reprimand is not a history make.
Have you had a reprimand within the past 12 months?
Yes.
Do you remember what the facts were concerning that reprimand?
Yes.
And what were they?
I was instructed that my shift was going to be changed, and I didn't want to change shifts.
So what did you do?
Well, I refused to change shifts. I just didn't show up that first day I was supposed to be on the new shift.
And what happened?
I got a letter of reprimand, and I changed shifts.
Do you know what you're required to do if you're given instructions by a supervisor?
Yes, if you're given an order, you carry it out.
All right. And if you don't like the order, do you have any way of redressing that situation?
Well, that's why I got the reprimand before.
But why was that?
Well, I was told to, work now and, take it to arbitration or, make a complaint.
Well, you don't have to take it to arbitration. You
Well-
can make a complaint how?
Just go to my shop steward.
Well, did you have a conversation with Mr. Hahn?
No, he said something to me, but I didn't have any conversation with him.
What did he say?
He came up and he was, he said he was gonna, if I was gonna leave now, and it was time for me to leave, if I was gonna leave now, I shouldn't come back to work the next day.
Did he say anything about the uniform?
No,
Did you say anything to him?
no, it was time for me to go.
And you just left without saying anything?
Yeah,
And did you come back the next day?
I sure did.
And what were you told?
I was told I was suspended.
All right, that's all I have.
I have a few questions on redirect. Mr. Kelly, after you commenced your conversation with Ms. Alvarado on May 4th, did you at any time return to the men's room?
No.
As a matter of fact, there wouldn't have been any need for you to return to the men's room.
I object, Mr. Arbitrator. The counsel is leading the witness.
The objection is sustained, and I would appreciate, counsel, if you would not lead the witness.
All right, Mr. Arbitrator. Would there have been any reason for you to return to the men's room at that point?
No, I was all ready to go as soon as my time was up.
Did you leave your place of employment before the shift ended?
No.
Can you tell me what time you left?
It was 6 o'clock.
I have no further questions.
All right. Thank you, sir.
Now let's stop here if you like. And you decide whose story you believe and why. And I'll be back later and share my decision with you. A conclusion in caps underlined, colon, paragraph. Thus, comma, for all the reasons set forth in the foregoing, comma, because all of the witnesses, both company and union, fell short in establishing a controlling credibility, and because it is the company that shoulders the burden of proof in discipline cases, comma,
The arbitrator must find that the company has not put forward a case convincing enough to produce a finding in its favor. Period, paragraph. This is particularly true because the testimony of the two supervisors, comma, Alvarado and Hoff, comma, did not persuasively establish the central core of the company's case, even recognizing that it is unlikely that they would have gotten together to concoct a false story, period. This crucial shortcoming in credibility thus precludes the company from prevailing and must direct the conclusion that Kelly's grievance be sustained, period. That is all on this tape. Thank you, Susan.